Welcome to this edition of The Tax Lawyer. I'm Scott Drake with my guest, partner at Wood LLP, managing partner actually, in San Francisco, California, the beloved Robert W. Wood. Rob, welcome back.
Thanks, Scott. Good to be here.
Not to belabor a point, but we're going to anyway. This is Independent Contractor Day here on the Legal Broadcast Network. We like to choose at least 1 or 2 days a month to talk about this specifically. This is an article you've written for Tax Notes, Independent Contractor or Employee, the 100-Year War. Rob, I guess the gist of the article is one particular case with a medical transcription company whose employees were tabbed as statutory, or their workers were classified as statutory employees by the IRS.
Right. Yeah, and I suppose the major, as you aptly say, Scott, we talk about these nitty-gritty independent contractor disputes a lot. I mean, they are intensely factual. There are a lot of them. In fact, there are lots of them that are IRS cases, and of course there are lots of them that are state tax cases, that are disputes with labor boards, disputes with insurance companies. I mean, they really are. They're everywhere, and I mean, there are certain similarities. I mean, it's almost inevitably an employer that has been treating people as independent contractors, and then somebody, the IRS or someone else, comes along and reclassifies them, typically retroactively, and so the numbers can be quite serious. And this is, I guess, in my 100 Years War metaphor, I was trying to compare this to various long-standing battles around the world. It really doesn't go away. And they're incredibly expensive, and very frequently, as I think I point out in this case, very frequently they could be put to bed either by a settlement or by some preventative steps for a heck of a lot less money.
Yeah, and the danger here in one of the cases that you cite, as you said, retroactive retribution going back 8 years, and you're talking about taxes and penalties, and for a small company, even a medium-sized company, that can be crippling.
Yeah, it can, and I think I think this is one of the dynamics here that often doesn't come through in the cases, although it did come through in this particular case of the transcriptionist, and that is often what the IRS is looking for is not huge dollars, and so it's kind of counterintuitive. I mean, you think of the IRS as obviously it needs revenue. The country needs tax revenue, but very frequently it's possible to get to a settlement if the client is willing to do it, where it is prospective only. That is where the government really wants to stop the bleeding, so to speak. They want to get the payroll tax. They want to get tax via withholding as opposed to maybe getting it later from the worker. And so I'm not saying that's a great resolution, because many people adamantly want to hang on to the independent contractor treatment. And that's true for companies as well as for a lot of workers. But sometimes, you can't have everything, and sometimes a reasonable compromise, if you can get it, is to make the past liability go away and simply agree with the IRS or whatever agency it happens to be to prospectively change. And I think it surprises a lot of people, a lot of companies, to know that those kinds of deals are pretty frequently available.
So the IRS isn't necessarily wanting to punish you and put you out of business. They just want you to get on the right track, is what you're saying.
It is. I mean, and again, I'm giving general comments. It's certainly not universal advice. And as I say, if you read the cases, sometimes you'd think what I'm saying is just wrong. Obviously, in litigated cases, I mean, the IRS is going after the money. What they want to do, though, frequently, as you said it, Scott, is sort of put the taxpayer on what they think, the IRS, think is the right track, and that's to treat people as employees. So, I mean, that, again, if you're facing what could be a crippling liability, that kind of a compromise about forget the past, we won't try to, address the past and pay a bunch of back taxes, but we'll change our method of operation going forward. As I say, that can be an attractive settlement in some cases.
And this is provided that the misclassification wasn't done with criminal intent, so to speak. And it sounds like because the area is so cloudy and determining a classification can take a lot of time, that the IRS would like to give you a break, knowing that you didn't do this intentionally and that it is fairly difficult. Would that be safe to say?
Yeah, no. Yeah, that's absolutely right. And again, I would stress that reading the case law sometimes doesn't give you this flavor. In fact, the case that I wrote about this time, these transcriptionists, I mean, this involves a dispute going well beyond the substantive dispute, and then fighting over attorney's fees, where basically the taxpayer was trying, and to a limited extent was successful, in getting lawyers' fees assessed against the IRS. My guess, though, is bottom line, this taxpayer was still out a pile of money for this rather big dispute. And I guess what I'm saying, it's somewhat against my economic interests, since these disputes are good for lawyers, people like me. But is it always worth it to go to the mat and to really fight? And I think sometimes people need to ask that question.
Robert Wood is my guest. He practices law with Wood LLP in San Francisco and writes frequently for Forbes and many other publications. He is also the author of Taxation of Damage Awards and Settlement Payments. Rob, always a pleasure. Thanks for joining us.
Thanks, Scott.
This has been a service of ATG Trust, by the way. You're watching the Legal Broadcast Network.